Okay, everyone, if you joined us for our relevance video, you'll know who we are and where we're going with this. This episode is about character evidence. We'll try to keep it as basic as possible. Forewarning, character evidence is one of the more complicated and complex parts of the rules of evidence, but issues of character evidence come up frequently, so having the basic understanding that we hope to impart in this video should help you quite a bit in responding to and understanding the objections and testimony that you're reading if you're going through the case or experiencing in trial if you're later in the year. I'm going to just pull up the rules, the applicable rules right here. It's Rule 404A, B, and then Rule 404B and Rule 405 are the rules we'll be talking about explicitly here. So I'll just go ahead and read what we got. Rule 404A1. Character evidence, which is what we're talking about here, is evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. That's a little bit wordy, but all it means is that having done something or exhibited a trait of character in the past can't be used as evidence that that trait of character or activity that happened in the past is happening now. So there are a few legal terms that we use to describe this phenomenon when you're using a past action to prove current action without any sort of other evidence associated with the current action, and it's called propensity or action in conformity therewith. So if you act in conformity therewith, it is acting in conformity with that past action in this case. Evidence of that type, according to Rule 404A1, which I've just read, is inadmissible. You want to be using the terms propensity or action in conformity therewith because those are the terms that judges are going to recognize. Even those judges who might not have a deep understanding of evidence because they don't use it on a daily basis, they will understand that term, that phrase, as the basis of how this rule works. That's how it was written in the past. The rules of evidence were only updated a few years ago now to have this new language of acting in accordance with a trait. So using the old terms of propensity and action and conformity can shorten your responses and better relate to a lot of the judges you'll have. So that's 404A1. Generally, testimony that goes to show action and conformity therewith or propensity is inadmissible.
Let's work through an example because that's sort of an abstract concept. So
sure.
I guess let's work with the speeding example since I guess people have some sort of frame of reference for that. Evidence that, let's say, the defendant, the
person who was speeding in this accident,
was a daredevil, a thrill seeker, right? Yeah. One of those adventure types who likes to go bungee jumping and whatever, all that other shit. Is that, in your mind, propensity evidence?
Grepsch?
Yes.
And the reason is?
Oh, okay. Because it shows a certain action or tendency for actions in a general class of I guess, in trial I wouldn't use the term recklessness, but recklessness or dangerous actions. So the character trait of acting dangerously or recklessly carries over to speeding 20 miles over the speed limit.
Yeah, the general idea is that evidence that a person is a thrill seeker, an adventurer, likes to do, crazy stuff like that, while it may be relevant in a way, it may tend to prove or disprove whether or not he was speeding at the scene of the accident. It's an improper leap to make, and that's what the character evidence rules are designed to do. Because what the plaintiff would be trying to show in that instance is that because he's an adventurer, because he likes to bungee jump, because he likes to do whatever, he must have been speeding. And that's an improper leap to make. It may be true, it may be relevant, but it's not a leap that the rules of evidence allow you to make.
the potential for bias against the jury, especially when you're getting into issues. So being a thrill seeker doesn't have an emotional connotation with it necessarily. Certainly it's not as strong of a one. But if you have instances of people having committed other crimes involving guns, for instance, and let's say someone shot a man in the past, went to prison for it, whatever, you can't elicit that evidence to say, well, he shot people in the past, he had this capacity to commit violent action, necessarily to say that he did so in this case, because you don't want juries punishing people in a given case for crimes that were done in the past. You want to be able to prove the issues and material facts within the case at hand. So that's the danger with propensity evidence under 404A. Moving down through the rule, if you're following along or looking on the screen, 404A2 applies, as the title says, only to defendants in criminal cases. We won't go into it very much because this year Park v. Duran is a civil case. Just know that when you do get to a criminal case, or if you're watching this at the beginning of the year in a criminal case, we should have a video specifically talking about this rule down the line. And furthermore, that it applies differently to defendants, the offering of character evidence, than it does to other witnesses, because defendants have different, really, a set of rights than just your average witness in a trial. So with that being said, we'll keep moving down through to 404B, which is pretty much a restatement of 404A, but specifically using, as the example I gave, the instance of crimes, wrongs, or other acts. So if someone committed a crime, committed a wrong, or committed another bad act, then those actions cannot be used, as 404B1 says here, to prove action in conformity or propensity in the given case. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. That's pretty much the baseline. You can't use, it's just a restatement, and specifically this is a type of instances that would be character evidence, in this case crimes, wrongs, and other acts. Although there is an exception to propensity when it comes to these types of instances of crimes, wrongs, or other bad acts, and that's 404B, and we're going to talk a little bit more about those. So you can offer evidence of this type that on its face looks like propensity if it is being used for another purpose, not to show action in conformity. So using the example of a thrill seeker, if you're not offering this testimony that he's a thrill seeker to say he was speeding necessarily on the day in question of the accident, to go back to our prior example, then it's okay, as long as the reason you're using it for is one of these listed under 404B. So we'll just dive into what the text of the rule is. 404B, permitted uses of character evidence, if there is notice in a criminal case, is what that second post-colon is referencing. But as this isn't a criminal case, that notice isn't relevant. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. There is a lot of this that is going to be available in Park v. Duran. So I just wanted to take a few moments and maybe reference a few examples that you might be seeing, or that you might think are fall under these categories from the case that you're working with this year. The one that jumps out to me, at least from this year, is notice. I think 404B2 notice is an exception that comes up a lot to character evidence, and it's particularly relevant here because when you might have these actions of Jesse, like shooting his friend in the video game, for instance. Perhaps you could argue that's a prior bad act used for propensity purposes by the prosecution or the plaintiffs to say, well, because he shot his friend in the video game, he must have shot Hayden in this case now. Obviously, that's an improper leap, and I think it kind of illustrates the point Matt was talking about. But you can be using it as the plaintiff not to show propensity, that because he shot his friend in the video game, he shot his friend in real life on August 18th, but to show notice that because the mother was watching while this was all occurring, the mother should have understood, should have been put on notice that there was some potentially damaging trait of character here that needed parental supervision. I think that's going to be a very common chain of arguments in this case, and I think it demonstrates pretty well how you want to use these exceptions in 404B.
Yeah.
They're very powerful. Interpret them broadly. There's going to be, probably when we go more in depth, we'll go through each of these, give examples for each of these, and say how in real life, so using real life case on real life examples, what all of these are used for. Identity, for instance, might read very vague. You might not quite understand what that might be used for. There's this very specific instance and a very specific reason it's there. When we go more in depth, we'll understand that. Just think about generally knowledge and notice and these words. When you're going through and thinking if a situation applies, interpret these exceptions broadly, and you'll probably more likely than not be right. So that's pretty much what 404B is. Does anyone else have anything to add on that front?
Yeah, I just want to say, sort of piggyback on the knowledge exception.
Another common one. Notice and knowledge are both very common exceptions, particularly in this case.
Yeah, that's going to be huge, because when you're on plaintiff, if you are doing negligent parental supervision, which I believe one of our teams is doing. Is it one or two? I think it's one.
At least one. We'll see.
At least in the fall. You have to prove the foreseeability element on the part of Hayden Duran. That is, Hayden was aware or should have been aware of the child's behavior and propensity to commit other acts of violence and did nothing about it. So all of that character evidence that can come out about Jesse Duran. I'm thinking, all the testimony from the expert couples. Maybe
perhaps
not.
the document, the note itself could be construed as an exhibition of character evidence.
The discipline notice from the school to the parent. All of that is putting the parent on notice or giving the parent knowledge of Jesse's behavior, thus making potential future behavior foreseeable on the part of the parent, which is a direct element of what you have to prove. So while character evidence is complicated, it's actually a bit simplified in this case because of that foreseeability element. Because all of that character evidence, or 99% of it, you can make a compelling argument that it goes towards foreseeability.
And as for if you're doing intentional shooting rather than negligent parental supervision, there are also some ones in 404B that'll help you, specifically intent, because that goes directly towards the intentional part of intentional shooting, motive, and like Mr. Covert said, knowledge as well.
Yes, knowledge about how Jesse could use the gun, if at all, goes to show that he had. So you might be saying, well, in the past he had operated a gun. I don't know if there's necessarily testimony to that regards, but it goes to show not that, well, he used the gun in the past, he used the gun now, but that he has the knowledge of how to use a gun properly. He has knowledge of how to check a gun for whether there's live rounds in the cylinders, whatever it might be. So that's how I imagine knowledge being interpreted in terms of intentional shooting. You could also imagine lack of accident or absence of mistake if you're trying to prove intentionality. If in the past he had used a gun frequently and had never made a mistake in doing so, yet in this case he's claiming a mistake, you could use those past instances to say, well, there wasn't a mistake in these instances when he was under similar conditions. So therefore it implies something about the intentionality in this case. There's no evidence that necessarily goes to that, but you can imagine it being added in, and perhaps there's examples that I'm just forgetting that could be construed in that way. So there's a couple
for the returning members from last year, if we look back to the Whit Bowman case, Whit Bowman, it can be construed anyway, was able to successfully operate the Tunnel of Terror hundreds and hundreds and hundreds of times, right?
Correct.
It was the one time where Cameron Poole was trying to escape that somehow he or she was unable to operate the Tunnel of Terror. So that would be an instance of absence of mistake in the past.
So that's 404B2, very useful and important as providing exceptions to the character evidence rule. We're going to move on. That's the bulk of it. So if you were having trouble, have no fear. That's pretty much the majority of character evidence. That's going to be 90% of the objections and the arguments centered around character evidence. Hopefully we did a decent job explaining and parsing it out for you. Just briefly, this is a couple mistakes that even highly seasoned teams will make, particularly ones that don't have a coach who is particularly trained legally. I'm going to look at Rule 405. The title should really explain to you what's happening here, but you have to have good reading comprehension and be reading with a discerning eye. Methods of proving character. So I guess I'll lead off with what the mistake is. The mistake that people make is that they believe 405 is an additional requirement for proving character evidence, or that 405 provides exceptions to character evidence. Neither of those are true. So there's two branches to 405, offering evidence of reputation or opinion and offering evidence of specific instances of conduct. I could list countless times when attorneys would get up there and say, this example of character evidence is a specific instance of conduct and is therefore not character evidence. No, 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 please God, no.
I've seen that so many times from good teams, and I just want to blow my brains out. Like, it's so bad. Like, if you interpret the rule in that way, if you interpret Rule 405 to mean it's not character evidence because it's a specific instance of conduct or because it's reputation or opinion, there is no character evidence rule then. Like,
because everything is one of those two categories, which is why exactly they're being offered as methods, listed as methods here.
So 405 only exists if under Rule 404 it's been determined admissible. Then you jump to 405 and say, okay, there are two ways of proving it. Either evidence of a person's reputation or opinion testimony, or a specific instance of behavior.
Correct.
And really, that's actually, it's kind of a redundant rule because what else is there, right? Those are the only two things it could be. But nonetheless, don't interpret that as those are exceptions. No, those are methods.
You have to be very diligent in having proper arguments to rebut these. Just be very clear, because sometimes these are good teams that sometimes make these arguments, and they can sound compelling to judges who might not have an in-depth knowledge of the rules, and you could even lose on these. It's not just an automatically known thing. This doesn't come up too often. So you have to be very clear in explaining what's going on to the judge, why the arguments being made by your opposing counsel are incorrect. And I'm just going to give one example of when methods of proving character, of like what is an example of reputation or opinion testimony. I thought of a pretty decent one from last year. So this example, I hope, illustrates the entire process of character evidence from its first being uttered in a trial to having to prove that that is admissible character evidence, that it's not going for propensity while using one of the 404B2 exceptions and using a valid method of proving character. I don't have one for this case yet. I haven't really thought deep enough to have such a robust example, but dating back to last year for any returning members, I'm going to be using J.C. Longstreet, the park owner, as an example here. J.C. Longstreet was cheap. J.C. Longstreet in the past had done many things to skimp on money in any way possible. So the trait of character at issue is the character of cheapness or frugality, whether you're thinking it's a good thing or a bad thing. And you can't necessarily say, well, because Longstreet was cheap in the past, he's cheap now. That doesn't work, because that's propensity or action and conformity evidence, impermissible under 404A. You would be using it in Rock2World to say that it's a motive for his actions. There was a theory of the case that J.C. Longstreet tried to skimp money from his own park through a staged robbery and theft by deception scheme in order to avoid paying taxes on that money that was collected. If that was the theory you were arguing, you could say that his cheapness isn't being used to show cheapness in the past, isn't being used to show cheapness in this instance. It's being used to show a motive for taking a certain action, namely helping stage this robbery. And if that's your argument, that seems solid. That should get by most of the time. And under Rule 405, you're using 405A, his reputation or opinion testimony about him, to establish that character trait. So you're establishing his reputation for cheapness through this reputation or opinion. Most of the time, the method by which character will be proven is by a specific instance of conduct on an account of a person. So I wanted to give an example that was a reputation or opinion. So hopefully, if you could follow me all the way through that example, that was a pretty in-depth example, one that goes beyond the level of most of the stuff we've been talking about. I would say 20% of mockers could really follow me all the way through on an expert level with that. So if you could follow me, like, you're good. You've got it. So that's 405. There's just a few more things left in character evidence here.
We still have 405B, which has there's a little different part of that, because in order to use 405B or a specific instance of conduct, so rather than testimony that J.C. Longstreet is cheap, you would have a specific instance of conduct of his cheapness. I can think back to his conviction for tax evasion, which is a different issue because it's a criminal conviction, or a specific instance of conduct of, firing safety workers. Let's say that was in there, right? You can only use that when a person's character or trait of character is an essential element of the claim or the defense in a civil case. That's a much higher burden. So you can't just throw around specific instances of conduct willy-nilly. It has to be a specific instance of a type of conduct that is an element of the
claim being made. If you're a plaintiff or prosecutor,
right,
or the defense that's being offered.
So I have two examples.
Sure.
One is from probably there's only a few people who in the program who did this case, but if you look back to the Danny Dawson case, the DUI case, there was a charge of recklessness, reckless murder. Now, he was a criminal defendant, but putting that aside, any specific instance of conduct that goes towards his reckless behavior, because reckless was an element of the claim, that would be something that would fit under specific instances of conduct. In this case, when you talk about, I believe it's intentional shooting, I believe there's something about willful misconduct, if I remember correctly.
That is the element, that is the state of mind required.
Right. So evidence of willful misconduct, and there are other issues that have to be dealt with, but just looking at it in a vacuum of this rule, evidence of Jesse's willful willful misconduct in the past would be something that goes towards directly a claim, an essential claim, an essential element in the claim, which would allow 404 or 405B to apply. So make sure you're not throwing around 405B willy-nilly. It's got to be to something that's essential in the claim.
We'll just touch on this next rule, 406, habit or routine practice. You can show that something is habitual or is a routine practice, and it is a separate exception to the character evidence rule. If something happens so consistently that it is habitual or a routine practice of a business organization, then you can offer it to show that because it happened in one instance, it happens now. The thing to keep in mind here is that habit and routine practice have incredibly high standards and burdens that need to be met. To show that something is habitual or that something is a routine practice, it is incredibly difficult to do, and you'll see teams trying to stretch this boundary far beyond what it was ever meant to. So that's my piece on this.
Two important things. The first is habit and routine practice evidence is not character evidence. So it's not an exception to character evidence. It's not a method of proving character. It is its own distinct form of evidence. And
well, it's a type of propensity evidence, which...
Sure, but it's not character. Right?
It is true.
Yeah. So propensity evidence is a big umbrella. Character is part of it. Habit, routine practice are part of it. But it is not character evidence. So make sure in your own mind to draw a logical wall between the two. The second is an example, and it's an example I think I've given every year that I've done this. It's sort of a textbook example of what habit evidence is. So let's say you've got a defendant on charge for murder, okay, and putting the fact aside that he's a criminal defendant, it's got its own issues. So let's look at this in a vacuum. This particular defendant is alleged to have committed a murder, and then left a red bandana at the scene of the crime. Okay. Now, the prosecutors and the cops have evidence of other murders that they've been unable to successfully connect to this defendant. Let's say he's a serial killer, right? But they believe that there's enough evidence to draw a connection to what they've actually charged him with. So let's say there are several instances around town where bodies have been found murdered in a similar fashion with a red bandana left there, and all that is missing is any identifying characteristic to this defendant. So let's say this defendant killed 5 people in the past. There's a red bandana there, and all of their throats were slit with an identical knife, a knife with a very unique, serration pattern or whatever, but no evidence connecting it to anyone. The 6th time, this guy screwed up. He left the red bandana there. He used the same knife, but this time he cut himself. His blood was found on the 6th victim, and that's how they're able to connect him to the 6th murder. So he's only been charged with this one, right? But evidence of those other crimes shows a habit or routine practice. Now, Alex might argue it may not meet the high burden of what a routine practice is, but I could argue that it is a habit. So that's the type of evidence that could be admitted to draw a connection between those people. It's just an example of something that's not character evidence. It's just a different way of looking at what habit evidence is. So it's not a character trait. It's sort of an action that is done repeatedly. Something that would be a routine practice would be, let's take that same defendant. Let's say he, all these murders are committed at between 7 and 7:30 a.m. in Central Park. Okay, evidence, let's say from a neighbor, right? This guy's neighbor, that every morning at 6:45 a.m. he takes a jog over to Central Park. That's a routine practice. That's evidence that while it doesn't mean anything on its own, it's relevant to show that he has a habit of being there routinely, hence routine practice, and thus it's more likely he committed those murders. So those are the types of evidence that Rule 406 is designed to allow in. You don't get a lot of it in mock trial, honestly. I mean, I can't even think off the top of my head when I've argued habit or routine practice, but it's there and it's good to know.
And the last thing in regards to character evidence, at least in terms of the basics, is the one big exception to character evidence. Mm-hmm. It's not in the 400s, but it's the one type of a person's character, the one trait of character that the law believes can be proven through propensity. So everything that you've read so far deals with traits of character being inadmissible if they are being used to show propensity, namely that if they were done in the past, that isn't evidence that they were done in this case. The one exception is Rule 608, and it goes to truthfulness and untruthfulness of a witness. It's right there in the title. When dealing, I'm just going to sum up this section because we'll have more on 608 specifically. Just know that if someone's character for truthfulness or untruthfulness is at issue, then propensity evidence is fair game in terms of attacking that person's bias and credibility for truthfulness and untruthfulness. One thing to note in regards to this, that does not mean you can go around and do the opposite of what the rule forbids. You can't go around and say, well, because this person has a habit of truthfulness, this person's such a great guy, so this person's never lied before, unless an attack has already been made. You can't just go around and do what's called bolstering without an attack being made prior or a notice being given that an attack is forthcoming. Just know that generally, but the big thing is that 608 type of character that isn't subject to the propensity rules of 404A. With that, I think we're pretty much done on character evidence. Thanks for watching. If you have any questions or comments, like always, either ask me if I'm still around, email us, or ask in the comments here, and either I, Matt, Dan, or whoever's running this page down the line will try and answer the best of their ability for you. Thanks, and we'll see you. Oh, I can't.